Hello, everybody. Welcome to IR Insights. My name's Paul O'Halloran. I'm an employment law partner in our Melbourne office, and really great to be joined today by Kieran Pender, who is an associate legal director at the Human Rights Law Centre and an internationally recognised authority on whistleblower protections. How are you, Kieran? Thanks for joining us.
Good, Paul. Thanks for having me.
No problems. So since joining the centre in 2020, Kieran has led the establishment of the Whistleblower Project, an Australian first legal service for whistleblowers. He's also the author of The Coast of Courage and co-authored Protecting Australia's Whistleblowers, a Federal Roadmap. Kieran has previously been a senior legal advisor for the International Bar Association's Legal Policy and Research Unit in London and has spoken on whistleblower issues at the United Nations, the World Bank, and the European Parliament and the OECD. So from the United Nations to our little Dentons podcast, we're very honoured to be able to chat to you today, Kieran. You're a busy person and you're not in Australia at the moment, so um, really appreciate it. Um, so Kieran, I'm just going to kick off with some questions for you and get straight into this really fascinating topic, which is of great interest to a lot of our clients, and we have noticed in our practice that whistleblower complaints and investigations have increased fairly significantly. I've noticed anecdotally over the last 12 to 18 months. Um, and interested to know, what sort of trends you've been seeing in that space. But as an associate legal director at the Human Rights Law Centre, what does your work involve?
Sure. Thanks, Paul. I guess the context is in Australia, we've had whistleblowing laws for quite some time now. The first Australian whistleblowing law was enacted in Queensland at the beginning of the 1990s. Every state and territory federal law followed. We've now got 17 different federal whistleblowing laws. Um, but there's been very limited legal assistance available to people who want to blow the whistle. And of course, your clients have the benefit of your counsel in navigating a whistleblowing process. If you're a whistleblower, where do you go to get help? Particularly because these frameworks are so complicated and the risks involved and the stress and the often the real challenges that face someone who wants to disclose wrongdoing are real. A number of years ago, we began working towards establishing a specialist legal practice for whistleblowers. We launched that a bit over 2 years ago, the Whistleblower Project at the Human Rights Law Centre, that really follows in the footsteps of a number of equivalent initiatives in other countries. So for decades now in the UK, in the US, in Ireland, in France, in Serbia, across Africa, there've been specialist legal services run by civil society to help people understand their rights under whistleblowing law and expose wrongdoing in the public interest. That wasn't the case in Australia, and so we wanted to fill that gap. Since we launched, we've really been inundated with potential clients. We've been contacted by almost 500 whistleblowers now. We've given legal advice to over 200, probably about 200 by now, and represented 40 or 50 of them on an ongoing basis. I think in part that reflects the fact that there was nothing there before, and so when we launched, there was a bit of a flood. But I think it also reflects this is a topical issue. We're seeing, as we'll come on to, a lot of law reform at the moment in both the public and private sector for whistleblowers, and that means it's in the media. People are talking about it. People are aware of their rights, and then they want to find out more, and then they come to us, and we try and help them.
Yeah, great. And so is that what the Whistleblower Project is, or is the Whistleblower Project something separate from that?
Yeah, so the project is first and foremost the legal service. We then also do a lot of public policy, law reform, and advocacy work. We're heavily involved in the current federal public and private sector law reform efforts, a bunch of different state and territory law reform efforts that are going on. And we also do a range of research pieces and advocacy pieces. For example, some of your listeners will be familiar with there've been in recent years a number of high-profile prosecutions of whistleblowers in Australia. We've done a lot of advocacy in relation to those cases. We intervened as a friend of the court in one of those cases as well. So we combine the practical perspective we get in the client work with the law reform and advocacy piece, and hopefully we make an effective contribution to the law reform because we're the only repeat players on the client side. Of course, there are many firms such as yours that are helping whistleblower issues from an employer side, but for us to be able to provide the perspective of the whistleblower across a range of matters that we work on, I think has been really useful for government.
Yeah, and I think you're right. It is a niche area. I mean, Dentons does a lot of work on the employer side when, investigating and responding to whistleblower complaints. But I'm aware of some colleagues in other firms that say, oh, I don't do whistleblower advice or investigations at all because it's too complex. So, there's obviously a great need for it. I assume I'm assuming most of our listeners know what whistleblowing is, but I guess in a nutshell, Kieran, how would you describe, what is a whistleblower, or what are the whistleblowing laws in Australia as they currently exist?
So, a whistleblower is someone who's exposing or raising concerns about potential wrongdoing in a work-related context. I like to think of whistleblowing laws as having three sort of qualifying parts to them. The first part is sort of the whistleblower scope. Who do these laws attach to? So, in the private sector, they attach to employees, contractors, subcontractors, officers, directors, and they even extend to volunteers. They extend to family members of all of those people. So, you've got a pretty broad scope. In the public sector, they're typically public servants and government contractors. So the first question is, are you someone to which a whistleblowing law applies? For example, if I sent you an email, Paul, and said, look, I think Dentons is doing something wrong, I wouldn't be a whistleblower because I have no relationship with Dentons in a legal sense. But if someone within the firm raises concerns to you, then they're potentially a whistleblower. The second question is, what's the nature of the wrongdoing that's being raised, concerns being raised about? In the private sector in Australia, and that law is the Corporations Act, there's a pretty broad application. It applies to a suspicion of a reasonable belief of wrongdoing or an improper state of affairs. Breaches of the law are one category, but that's a fairly broad definition, and there's some case law that supports that being pretty broad. And the whistleblower has to have a reasonable belief in the wrongdoing. So if the person blows the whistle and it turns out they were just wrong, that's still a protected whistleblowing disclosure. But if they, had no reasonable basis for raising the concern, then it wouldn't be. Some of the public sector laws are a bit more prescriptive. They say, certain categories of things, maladministration, corruption, misfeasance, and so on, are the categories to which those laws
Mm.
apply. And generally, whistleblowing laws all exclude personal work-related conduct unless it's systemic. So if you're unhappy with your boss, if you're being bullied at work, raising a concern about that is not whistleblowing. But if your boss is bullying 10 people and there are serious work health and safety issues, then that could fall within the whistleblowing basket. The final question is, who do you blow the whistle to? And whistleblowing laws vary, but typically if you blow the whistle to a senior person within your organization, an officer or a manager, if you blow the whistle in some cases to a regulator under the private sector regime, that's ASIC, the corporate regulator, or APRA, the banking regulator. And then in certain circumstances, you're also, as a last resort, able to blow the whistle to a journalist or to a member of parliament. You can also always blow the whistle to a lawyer for the purpose of getting legal advice. That's where we come in. So the question is, do you sort of fit through those three different hoops? Are you someone to which a whistleblowing law applies? Are you blowing the whistle on something that is covered within the law? And do you blow the whistle to someone who is eligible to receive the whistleblowing disclosure? And if the answer to all of that is yes, then you're a whistleblower and you've got all of these different rights and protections under the law. And someone who's receiving that sort of, if you're a company receiving that information, you've got to be alert to that legal framework so that you're ensuring that the legal framework is upheld.
Great summary of the framework there. I think just listening to your description there, something that is often, I think, misconceived by employers is the so-called carve-out for personal work-related grievances. And there's a view that, anything that might relate to some dissatisfaction or a grievance that an employee has um, is automatically excluded if it might relate to, discrimination or sexual harassment, because it's not considered to be corruption in a sense that some clients think that it's only corrupt behaviour that falls within whistleblower protections, which I think is a misconception. But I would definitely encourage our clients to get advice about that because, as you suggest, if it's systemic or it's a larger scale and it's more than a sort of one-off incident, it could be captured by the whistleblower laws and need to be investigated.
But I totally agree, Paul. But even something like sexual harassment, because sexual harassment is unlawful under the Sex Discrimination Act, even a one-off incident could give rise to complex questions as to whether that personal work-related carve-out is engaged, because the bar is otherwise including unlawful conduct. And so if someone says, "Look, I've been sexually harassed," not only could that be covered under the Sex Discrimination Act, it could also give rise to whistleblower protections. And so being really careful as to how you apply that carve out. Equally, I think sometimes the carve out does exist for a reason. This is a
Mm.
specialist regime with specialist protections. You don't have to funnel every issue through a whistleblowing framework. There are some, garden variety employment concerns that don't rise to the level of whistleblowing, and it's important that you don't necessarily treat those as whistleblowing because otherwise it can make it much more hard work for everyone involved, because once you're in whistleblowing land, you've got all of these confidentiality protections and so on that make it harder to deal with sometimes.
Yeah, absolutely. So the current framework, as you've said, covers alleged misconduct or an improper state of affairs or circumstances in a company. What protections do you think are missing from the current whistleblowing laws?
Um, I think the first thing to say is the federal whistleblower. If we sort of focus on the federal level, the framework is far too complex. We have a public sector whistleblowing law, a private sector whistleblowing law, and we then have all of these sector specific whistleblowing laws. So at a federal level, we have whistleblower protections in the aged care sector, in the NDIS sector, in relation to tax related whistleblowing, Aboriginal and Torres Strait Islander corporations, the union context, on it goes. We've got 9 different federal whistleblowing laws, and they are all different and often they overlap. So it's very possible to be a whistleblower or an employer covered by whistleblowing laws and be covered by 2, 3, even 4 different whistleblowing laws. That is obviously not a desirable state of affairs for a whistleblower not to know which legal framework applies and what the differences are between them. So that's a major concern. At the moment, the Albanese government is reforming the public sector regime and recently has commenced a review of the private sector regime, the Corporations Act regime. So hopefully some harmonisation and consistency comes as a result of those processes. There are then some sort of more specific improvements that we and others would like to see to the law. Um, but part of the challenge is not so much the law itself, but the framework around it. The law on paper is reasonable. It's not working in practice, and in part because people can't get the support they need. We don't have a dedicated whistleblower support office in Australia. ASIC, which oversees the private sector regime, has very limited resources. In a number of other countries, there are independent whistleblower protection authorities that have been very successful in ensuring that whistleblower protection works. Whistleblowers are able to access legal support and non-legal support. And in Australia, other than our legal service, I mean, our work is all philanthropically funded. We obviously have a fairly limited capacity. That support doesn't exist. So our work with the government to date has been, look, fix the law. There are improvements, and there are improvements also just at a technical level in making it work more effectively, because when they work effectively, it's good for employers, it's good for whistleblowers. But then the missing piece, as we see it, is that oversight and support infrastructure.
Mm. Interested to know how the centre decides what sort of matters it will take on, because you must be very limited in your resources. Do you have some sort of criteria that you use when selecting cases?
Yeah, that's a great question, Paul, and we do. The first thing is, everyone who comes to us, we try and provide some assistance. So whether that's, we've got like a number of flow charts that explain how the laws work, we've got templates to help people make disclosures, we've got guides and materials and so on, and so we try and provide that, and or we refer them to somewhere else that might help. So often people come to us thinking it's a whistleblowing issue and it's actually an employment issue or a discrimination issue. And so we provide them with the right referrals. But as you say, we can't substantively help everyone. We have intake criteria that are aligned with, for example, our charitable purpose as a charity, the areas of work that the Human Rights Law Centre focuses on, the systemic issues, the public interest issues, the legal issues. Could it be a test case? Does it have strategic significance for whistleblowers generally? And we sort of, some people we at the beginning say, look, we can't help you. Some people we give initial advice to, and at least we've given them some legal advice, and then we say we can't help you any further. And then the cases that we're taking on and representing on an ongoing basis typically have that wider systemic public interest component, either because of the legal issue or the wrongdoing involved. So, if someone's exposing really significant wrongdoing that we think's very much in the public interest for it to be raised, then we try and prioritize that. What I think is interesting about our work is it can take a whole range of forms. So some of our work is helping people bring concerns to an employer, navigate the internal process. Issues can be resolved at that level. Great. Sometimes it's helping them go, they've raised concerns internally, nothing's happened. We take them to a regulator, again, navigate that process. It's really stressful to engage with a regulator, to be issued with notices, to have to go through that process, and we can hold someone's hand and assist them and advise them through that. In some cases, and I think when people think whistleblowing, they probably think on the front page of the paper. And, we have a lot of clients who we do ultimately take through those protected pathways to go public. But I think what I find is actually we have some really impactful cases there, but a lot of the work we do is actually behind the scenes. No one ever sees it happens, but we get really good results. If we raise concerns with an employer on behalf of a client, I think that because of our expertise in this area and because of our profile, people take the concerns seriously. Most whistleblowers, that their goal is, almost all of our clients, their goal is not to be on the front page. Their goal is for the wrongdoing to be addressed. And if that can be addressed at the beginning, great outcome. Some of the most successful cases I think I've worked on are where, you help someone speak up in a safe and lawful way. It's dealt with. They never even need to think of themselves as a whistleblower. They've done their job. They've raised a concern. They've got advice as to how to do that effectively. The issue's addressed. Everyone can move on.
Yeah, great. A bit of a strange question, I suppose, but is there anything that you won't take on from a whistleblower, like in terms of the type of conduct alleged or the company that it's alleged against?
Uh, we can't help national security and intelligence related whistleblowing. There's really significant carve outs for people in that space to get legal advice around their whistleblowing. Obviously, I don't want to go to jail, so we're very careful as to what we can and can't do in that context. I think we're mindful of the overlap. One of the tricky things is obviously whistleblowing issues often correspond with employment issues generally, or with workers' compensation issues. Particularly, we see that to be the case. It's funny because I think sometimes employers think that there's a sort of a nefarious connection there. Someone goes on workers' comp and then they put in a whistleblowing claim.
Mm,
But I think from our clients' perspectives, it's often once they're out of the immediate environment, that's when they're in the position to say, actually, I saw this thing that was wrong and I feel safe now speaking up about it. But we're not workers' compensation lawyers. We don't provide a general employment service. And so navigating what we can and can't help with is difficult. But otherwise, we in theory would help with any type of wrongdoing as long as it meets the legal tests. Noting that the wrongdoing doesn't have to exist itself. The person just needs to have a reasonable sort of belief in it.
yeah, interesting. So, talking about some of the cases that you've worked on, and one in particular, to the extent that you can talk about it in a more public forum, is relates to Richard Boyle. So, this is a case where the Human Rights Law Centre intervened as a what's called a friend of the court. What can you tell us about what that involved, and why the centre chose to intervene in that matter?
So, as I said earlier, Paul, the in recent years, there's been a number of whistleblowers being prosecuted in Australia. That's been of really significant concern to us, both because of the injustice of the particular cases, but because of the chilling effect that prosecuting whistleblowers has on all of our client base. I can't tell you the number of clients who've said to us, I'm scared about blowing the whistle because I see whistleblowers being prosecuted, whistleblowers being imprisoned. So we've done a lot of work advocating against those prosecutions. We're glad to see that the Albanese government discontinued the prosecution of Bernard Collaery, who was the lawyer for the intelligence whistleblower witness K. Unfortunately, the David McBride case and the Richard Boyle cases continued. Just recently, after losing a defence, an issue, an sort of interlocutory issue in relation to a defence, Richard Boyle pleaded guilty and ultimately received a no conviction order in what we saw as a really significant silver lining, the judge recognising that the public interest in what he had done. For those not familiar, Richard Boyle was an employee at the Australian Taxation Office, blew the whistle on wrongdoing in the ATO, blew the whistle internally, went to the oversight agency, ultimately went to Four Corners, but was being prosecuted not for going public, but for what he did in preparation for the internal whistleblowing. So one of the issues that case threw up, and what we intervened, unfortunately unsuccessfully, in relation to, was to what extent do whistleblower protections extend to conduct prior to the actual act of blowing the whistle. So, when you send the email saying this is a whistleblowing disclosure, you're protected in relation to that. You've got immunity in relation to that. But in Boyle, the Court of Appeal said that the protection didn't extend to any preparatory conduct, no matter how essential to the whistleblowing. So anything you do before the actual act of blowing the whistle is not protected. Uh, that's a really unfortunate outcome for whistleblowers at a really practical level. Like, we see a lot of our clients, there's preparatory conduct that necessarily happens to blow the whistle. If you work in the private sector, there's risk to your employment. There could be civil liability that goes with that. In the public sector, there's criminal risk because of secrecy offences and so on.
Mm,
If you're a public servant, you see something dodgy at work, you take home an email that evidences that solely for the purpose of mailing it to the National Anti-Corruption Commission. In just taking home the email from work, it could be unclassified. It's not sensitive, but just that piece of
right.
government information, you've
Yeah.
broken secrecy offences, you've committed theft, you've breached the code of conduct. If you're a private sector employee in those circumstances, you will have you could face confidentiality sort of related liability. You've got to draw a line somewhere. No one's saying whistleblowers should be able to break into safes to get information, but we think the line in this case was not drawn in a place that's reasonably practical for whistleblowers. So there's currently a law reform process considering that and other issues.
Yeah, really interesting. I didn't know about the case to that level of detail, so thanks for explaining that. There's some legislation that's been reintroduced into Parliament, I think in July this year, the Whistleblower Protection Authority Bill. If passed, that would establish a Protection Authority. What can you tell us about, firstly, I mean, to the extent that you know, the likelihood that that has or will pass, and what would the authority look like, and what would its powers be?
In its current form, that bill won't pass. It's a private member's bill from Senator David Pocock, Senator Jackie Lambie, Andrew Wilkie MP, and Dr. Helen Haynes MP. But it's a really critical policy piece of policy work demonstrating the need for a whistleblower protection authority and what that would look like. So it's a really significant piece of legislation that demonstrates, just as the National Anti-Corruption Commission grew out of private members' bills demonstrating what a National Anti-Corruption Commission could look like, similarly, that's what this Whistleblower Protection Authority legislation does. Um, that would be a body that oversees and enforces whistleblower protection laws and provides support to people who use whistleblowing laws. So guidance to employers and support and practical support to whistleblowers. As I said earlier, not a radical idea. We've got equivalent bodies in the US, in the Netherlands, in Slovakia. I'm actually in Spain today. I'm speaking on a panel with the new head of the Spanish Whistleblower Protection Authority that was just set up recently under Spanish law. So I'm really excited to hear what that person has to say. It's not a radical idea in the Australian policy context either. We've had recommendations from different inquiries and reports into this idea over the decades, but we haven't yet got around to it. In response, the government has said that it's going to set up a whistleblower ombudsman within the Commonwealth Ombudsman for the public sector. That's a good start, but our concern is it doesn't go far enough and it further fragments the whistleblowing landscape. So at the moment, you've got ASIC that have some whistleblowing functions, but not the dedicated functions they need. Got the ombudsman, you've got this new whistleblower ombudsman. We think we need a holistic, integrated whistleblower protection framework. One of the reasons for that, Paul, is you can't really, in this day and age, neatly divide up public and private sector. You've got so many private sector entities doing work for government, adjacent to government, often covered by both public and private sector whistleblowing laws. And so we think trying to sort of keep these regimes overly separate is not a good idea. So, really important bill that went to a committee inquiry, really important committee report that considered the need for greater protection for whistleblowers. As yet, the government hasn't committed to doing that. We hope that will come, but in the interim, they're proposing to set up a whistleblower ombudsman for the public sector, which is, a good step forward.
Interesting. So I'm interested in understanding too the gendered elements of whistleblowing because this centre put out a report in August of this year that showed a third of women faced harassment and bullying because of whistleblower disclosures, compared to only 9% of men. So if we've got those statistics right, why is that bullying and harassment so much higher for women?
Good question. So the impetus for us to do that research was that we've had a number of high-profile whistleblowers in Australia, all of whom have been men, and we wanted to look into, what does our client data say about, who a typical whistleblower is in Australia, and we saw that quite a number, in fact, a majority of our clients are women. There are some interesting differences between what men and women blow the whistle on. We saw that men are more likely to blow the whistle on for fraud and corruption style issues. Women were more likely to blow the whistle on issues that were endangering people. Had a lot of female whistleblowers in the health, aged care, disability style contexts. And then often the experience of whistleblowers, both male and female, is that they experience retaliation, but that there was a gendered component to that. This is early stage research. There's been some emerging equivalent research in other countries that's only just beginning to get into the issue. So, we don't say we have all the answers, but I think beginning to bring a sort of a gender sensitive lens to these issues, thinking about the ways that the experience might be different for men and women is really important to the debate. And for us, it was just making clear, a whistleblower can be anyone. And the problem, of course, a lot of attention on these high profile cases for very, obvious and important reasons, because these were really high profile cases of injustice. But we don't want people not to be able to see themselves as able to access these laws and these supports. I guess the next phase for us is also thinking about people from culturally and linguistically diverse backgrounds. Can they access the materials? Is there whistleblowing material in different languages and so on? We've done some work in relation to migrant workers and the sort of the unique challenges that they face to blowing the whistle because of the visa vulnerability. So just beginning to think more laterally about who is a whistleblower and what we need to do to ensure that people who speak up, whoever they are supported.
Yeah, and any views on anonymous complainants as opposed to non-anonymous? Not that this is a solution, but I guess if you're in a vulnerable category, maybe you're better off making an anonymous complaint rather than being so visible.
Yeah, so most Australian whistleblowing laws allow anonymous whistleblowing. I think in practice we find there can be barriers to the extent to which an employer can investigate when concerns are raised anonymously. They might not have all of the context. But I think what we find is often it's about like an ongoing journey for the whistleblower to get them to a point where they feel safe and comfortable disclosing their identity. So if someone makes an anonymous complaint, but there's a channel that allows ongoing communication. So often companies have speak up platforms that allow that back and forth, even with an anonymous whistleblower. It can be about explaining the process to them, getting them to a point where they're comfortable disclosing their identity. Or in some cases for our clients, like we will be the barrier between them. So we'll write on their behalf to the company and say, look, we act for one of your employees. We're invoking their right to be anonymous, but this is what you need to know. It definitely is something that goes to encouraging someone to speak up, but then part of the journey is ensuring that the wrongdoing can be investigated, and when someone's anonymous, that can come with difficulties. But I think it's about employers taking their obligations around confidentiality really seriously. So the law says you've got to protect a whistleblower's identity. There are criminal and civil offence provisions that go to that. You've got to get that right. You've got to make sure that while you're investigating, the whistleblower's identity is protected, because then you can retain their trust and confidence that you are protecting their identity.
Yeah, yeah, good points. Now, Kieran, I'm just looking at some research that one of my lawyers has prepared, and I can't help but think this is wrong. And if it's not wrong, it must be. It's very alarming, but it relates to workers in the healthcare sector. Um, can this be right? 100% of workers in the healthcare sector suffered reprisals following reports of wrongdoing. Um, that's pretty concerning if 100% is the data that you've got. Why is the
Yeah,
fear of reprisal so high in healthcare?
that was the finding from our recent report on the gendered sort of aspects of whistleblowing. Is really concerning. I don't really have an answer as to why that is. Obviously we have a small limited sample, so we're not saying that that's exhaustive of the situation. But I do think in these areas where people are speaking up about, potentially life and death matters, it's all the more important. We've got the speak up infrastructure, we've got the support frameworks around whistleblowers. And at the moment, in that context, the suggestion was that's not something that people are not being supported. And when they do speak up, then they're often suffering retaliation. So that's a real area of concern. Relatedly, aged care, disability sector, we're seeing a lot of whistleblowers in those contexts, and the law and the framework there can also be quite confused and complicated. Often in these areas, there's like a real public-private overlap, a state-federal overlap as well. So a difficult area in which to blow the whistle, but so important. I guess
Mm.
often when we think of whistleblowers, we might think of big high-profile fraud, corruption. But if someone's not being looked after in hospital, if there are systemic failings, a very famous Australian whistleblower is Tony Hoffman from Queensland, who blew the whistle on Dr. Death at Bundaberg Hospital. So we've seen very live examples of whistleblowers playing a critical role in saving lives. We've got to make sure we're protecting those people.
Yeah, absolutely. Now, Kieran, with all of your insights from, I guess, the employee individual perspective of complainants, um, understanding that there's several hundred people who have registered for this webinar from companies as Denton's acts for employers, and some of the biggest employers in the world have registered. What would you like employers to know about whistleblowing complaints? What is there anything that you can pass on to our listeners that may give them an insight into how they can improve their practices, approach, or processes when it comes to, I guess, investigating and resolving whistleblower complaints? Like, are there some common things that come up where you just think, if only employers did this, then we wouldn't be in this situation?
Great question, Paul. I think my overarching comment would be approaching it in a collaborative manner. I think often because the legal framework is, quite scary, there's a lot of, really serious provisions in there. Employers can sort of, obviously they should get legal advice, but it can become very adversarial very quickly. Whistleblowers are trying to help people speak up because they think it's their job. They see something wrong at work, they want to speak up about it, they want the wrongdoing to be addressed, and encouraging employers to see whistleblowers as an asset to addressing risks before they escalate, is so important. I often think there was a matter we were involved in where we helped someone raise concerns internally. They weren't dealt with. We helped them escalate to the regulator. They weren't dealt with. We helped them go to the media. Led to a total media storm and a lot of accountability in that context. It never needed to happen. If that person had been taken seriously at the beginning, if they'd been engaged with in a collaborative, respectful way, the employer could have resolved the issue and everyone could have moved on. So, of course, sometimes, there are complex legal issues at play. Sometimes, and employers always need to take those seriously and get good legal advice, but encouraging them to come at it at an attitude of the whistleblower is trying to help us. How do we take that on board?
Yes. And I think rarely things happen in a vacuum. I mean, what I tend to see with whistleblower complaints is something's been bubbling along for months or years. And sometimes there's knowledge of it, sometimes there's not knowledge of it. And then ultimately, there's a sense that not much is happening internally. And then a whistleblower complaint is lodged, usually as a last resort.
Mm.
Um, and then that's when we sort of usually hear about it. So I think it's probably rare that they come out of nowhere. I'm not sure if that's your experience, but I expect that complainants usually try various different avenues, whether it's an, anti-bullying application in the Fair Work Commission, or there's a internal complaint or grievance process or a mediation. The whistleblower complaint usually comes later and sometimes after the employment ends. So that's what I tend to see, but I guess these things come in all different shapes and sizes.
Mm. But I think even in those contexts, someone said to me, often after you make someone redundant, that's when they blow the whistle. And that doesn't mean that the whistleblowing is not legitimate.
Mm.
There's often talk about like a whistleblower's motives, and I always think, you know, we're not interested in the motive, we're interested in the information. And of course, it might be that the information, doesn't sustain a whistleblowing disclosure, that there isn't underlying wrongdoing, and then that's fine, and you can deal with that accordingly. But whatever the context for someone raising concerns, is there legitimacy to the concerns? And if there is, then you should deal with the wrongdoing.
And just in terms of, those employers who decide not to investigate legitimate whistleblower complaints or refuse to, um, what are the consequences for employers that are in that category?
I guess the consequences are that if the whistleblower doesn't feel that the issue has been addressed, then they'll escalate it. And the law allows a whistleblower to escalate to a regulator, and ultimately, as a last resort, to escalate to a member of parliament or to a journalist, and to be lawfully protected in doing all of that. But as I said earlier, like, none of my clients, that's not the end goal. The end goal is addressing the wrongdoing. I've had clients where the employer has investigated, they haven't sustained it, but they've explained that to my client, gone through the process that was undertaken, the findings of that. Maybe even if the wrongdoing isn't sustained, there are some sort of changes that can be made to practices and so on, and that can be a really validating and experience for the whistleblower, that leaves them feeling that they've been taken seriously, even if the wrongdoing wasn't sustained. Things have happened, and they can then leave it at that. But it's often the cases where concerns are brushed aside, processes are skipped over, that the whistleblower feels like, look, I'm not being taken seriously, nothing's being done, I see the wrongdoing still happening. That's when I'm going to escalate it, and that's when you've got regulators involved, and ultimately potentially the media.
Mm, yeah. Great. Well, Kieran, is there any aspect of whistleblowing that we've not spoken about today that you'd like our listeners to know about?
Just to say, Treasury at a federal level is currently reviewing the private sector whistleblowing law. I think there'll be a consultation paper out in the next few months. So it's sort of watch this space, but they'll be seeking submissions. So for people that, have a lot of experience with whistleblowing law in their organizations, applying those laws, if they have insight to share, I think it's really important that that law reform process is as informed by different perspectives as possible.
Yeah, absolutely. Now, many of our listeners may be wondering where they've heard your name from before and not necessarily associate you with whistleblowing, but perhaps writing sports articles for The Guardian and other publications, which is something that you do on your spare time. And a lot of the lawyers in my team know you for that, actually. So, how did you get into that, and how have you got time to do that with everything else that you do?
Before I became a lawyer, I was a sports journalist, and I've been fortunate to keep it up. Fortunate to have supportive employers, and I've been writing for The Guardian, their Australian branch, since they launched in 2013. So I'm fortunate that they sort of put up with the fact that I just sort of come in and out. I've been fortunate to cover the last two Olympics, bunch of men's and women's World Cups, Tour de France, and so on. It's a good side
Wow,
hustle.
that's amazing. How do you manage your schedule, or do you have somebody do that for you?
I manage it, but I don't sleep a lot.
Busy person. Well, knowing how busy you are and that you've got an important conference in Spain, Kieran, I want to thank you for taking the time to talk to us today about this really complex, interesting, and insightful topic. Um, of course, this session is pre-recorded, which our listeners will get sometime later next week. But anybody with any questions, feel free to email them through. If there's any for Kieran, we'll pass them on to him. Um, and yeah, Kieran, thanks a lot for your time.
Thanks, Paul. Speak soon.
Thanks, everybody, and look forward to chatting to you next month. Have a great week.